MES has proposed to strengthen the current outsourcing regulatory framework. The current regime is set out in a form of outsourcing guidelines, which do not have force of law. Under this new proposal, the MES will be setting out the regulatory requirements in the form of a notice. The difference is that the notice will have the force of law, and that means that any contravention of the notice will give rise to a regulatory breach or even a potentially criminal sanction. The key thrust of the outsourcing guidelines is really to strengthen the internal processes of a financial institution in managing outsourcing risks. We also see quite a bit of focus in relation to the protection of customer information, which is not surprising in light of the introduction of the Personal Data Protection Act in Singapore. And we believe that the MES also had looked at previous breaches, some of them rather high profile, in relation to the loss of customer data, which is done through or as a result of an outsourcing arrangement. There is now a wider definition of what constitutes outsourcing. So potentially a lot more activities could be deemed to be outsourcing. There is a concept of material outsourcing under the regulatory framework. Something that's considered as material outsourcing will be subject to more stringent regulatory oversight by the MES, is also subject to more onerous requirements on the part of the financial services conducting the material outsourcing. Under the proposed consultation paper, the definition of material outsourcing is widened. So long as an arrangement includes customer data, it will be deemed to be material outsourcing. And this means that there will be a lot more instances of outsourcing arrangements which will be deemed to be material outsourcing. There's also more prescription in relation to the assessment of service providers. There's a lot of focus in terms of ensuring the protection of confidentiality of data, whether in terms of requiring legal opinions where outsourcing is done in a foreign jurisdiction. There's also a lot more prescriptions in service level agreements that needs to be put in place. And there's also a bit of focus in relation to outsourcing arrangements done within a financial services group to its overseas affiliate. And relook whether any current arrangement would fall within the expanded definition of outsourcing, as well as a broader definition of material outsourcing. It also has to review its current program of reviewing the service provider, because there are more onerous prescriptions. The financial institution has to rework its register of outsourcing, because there's now a prescribed format. It has to relook at the service level agreements, because there are new prescriptions in place. And when in relation to overseas outsourcing as well, or outsourcing to an overseas entity, it now has to obtain legal opinions in relation to the jurisdictional risks of that relating to that particular arrangement, and in particular focusing on the adequacy of data protection laws of that overseas jurisdiction. And the other thing that's probably more onerous and problematic in my view is where outsourcing is done to an overseas financial institution, because here the MES now expects the financial institution to obtain a written confirmation from the foreign regulator overseeing that overseas financial institution, to the effect that it will not access the information other than the purpose of carrying out supervisory function, and it will provide to the MES prior written or to obtain the prior written confirmation from the MES before it accesses any customer information. So it might be quite onerous for a Singapore financial institution to arrange to get that written confirmation from a foreign regulator. In light of these far-reaching proposals, I think it is important for financial institutions really to go back to basics, adopt a risk-focused approach, look at your outsourcing arrangements, identify where the risk areas are, and focus your resources on those risk areas, particularly where material outsourcing is involved and when customer information is involved, I think it's also useful to commence a review of service level agreements to make sure that they are future ready, because I think it is probable that a lot of these proposals made by the MES will come into effect pretty soon. I think the one practical difficulty relating to obtaining confirmation from a foreign regulator, in relation to that, I think there's been some feedback given by the industry to the MES that this might be too onerous for the industry. There has been suggestions that the MES could rely on the regulator-to-regulator route rather than getting a financial institution to obtain a confirmation from a foreign regulator. But if that requirement gets pushed through and becomes a regulatory requirement, I think it might leave a financial institution little choice but to perhaps be able to demonstrate that it has done quite a bit to obtain that confirmation from a regulator, and if there is an inordinate delay, maybe to speak to the MES in order to get some form of dispensation. Or if there are other mitigants, for instance, if it's able to obtain a legal opinion on the strength of data protection regime in that foreign jurisdiction, that should be good enough mitigant for the MES to consider.